Hi, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. I am the owner and managing attorney of Campanile Law. As always, if you want to talk estate planning with me, I'm open to talking. When we talk, it is free for the initial consultation. You can reach me at njestateattorney.com. So today's topic comes from something that over the last, I'd say, year due to COVID, I'm seeing more and more people opt for because it's the cheapest way to do things, and it pertains to your bank accounts. So pertaining to bank accounts and estate planning, there are a couple things that we have to do and look out for. So what I'm seeing a lot is that people are creating more and more joint accounts, especially because people don't want to pay for estate planning. They feel it's too much, so their theory is, let's do a joint account, and they do these joint accounts. Well, there are some issues with this because you think about it. If something were to happen to you, if you were to pass, that person that you own that joint account with becomes the full 100% owner of that account. So if you have two other people you own the account with now, and you pass, now whatever was in that account, it's now split 50-50. It doesn't get transferred to your estate. So that kind of becomes a weird thing, because let's say you funded that account fully, but you put this person on and they haven't put anything into it. Now they get all of that money that was yours that you may have wanted to give to somebody else. So that's just kind of a caveat of a joint account right now. And it always is. The other thing that, and before we leave this part of the topic, but the other issue is if that person, that co-owner of that account, gets sued for anything. Let's say they don't pay a contractor or they're liable for something. They file bankruptcy. Well, guess what? That account, even though and their name's on it, can be attacked, or their creditor could go after that money, and you could be left with absolutely nothing. So just a thought that you'd want to think about. The other thing that people are doing more and more is they're going to their banks and they're getting signers on the account. Now, what is a signer? It's basically somebody that has authority to add money and withdraw money from the account. That's basically it. What I recommend, if this is the way you're going, is set up your power of attorney and medical power of attorney, because if you become incapacitated, if you can't handle your affairs, this is just going to give that individual greater powers. So why wouldn't you give this person that you're going to give these signer abilities to the account all the control? Because there's going to be a time where you can't handle things, and that signer is going to need more leverage than just adding and subtracting money from the bank account. They're going to have to pay your bills. They're going to have to make a decision for you. They're going to have to manage all your accounts, make sure your cell phone, your electric, gas, mortgage, all these things are paid for. They can't do that with just that power of being a signer. They need these additional foundational documents of a power of attorney and medical power of attorney. So there's that caveat. And the last caveat, I'm drawing a blank here for a second, is I believe that's... Oh, the last thing I want to talk about is, if you really are, the best way to set up these accounts, if on your checking account, your savings account, or what have you, what I always recommend is, look, to get these out of the probate process, to avoid the expense of probate, even though probate process is relatively inexpensive in the state of New Jersey, is to put what was known as a transfer on death or a payable on death account. So basically what this does is you would nominate. So let's just say I wanted to set up an account, and on it I say transfer on death to Mike Smith. So when I die, that account does not go into my estate. It's just going to pass right to Mike Smith. And he'll take the assets that are in that account. And here's the thing, I could have one checking account, I could have an infinite number. So if I have one checking account, but I have 4 people I want to leave things to, I can go to the bank and in my transfer on death documentation, I can say 25% of the total account to Mike Smith, Jane Smith, Dan Smith, and Chloe Smith. So we have those options. You could even give a numerical amount. So you could also say $1,000, $1,000, $1,000, $1,000. It's all up to you. The key here with the bank is make sure you've executed these documents and provided them to the bank to be filed. It is incredible how many times people sign these documents, think they've been handed over to the bank to be filed, and make the proper account changes or add the transfer on death or a signer, and then they find out when it's too late and nothing can be changed, and it all goes into the estate process and probate process. As always, my name's David Campanile. I'm the owner and managing attorney of Campanile Law, located in the great state of New Jersey. I hope you found this video informational and informative today about bank accounts. As always, also remember, if you want to talk estate planning with me, you can contact me at njestateattorney.com. And just remember, before you act on anything, please speak to your attorney to make sure this works for you. And again, I'm David Campanile from Campanile Law. Have a great day.